right, we can go ahead and call Mr. Smith's matter if the parties want. That is 25T435. Mr. Smith appears before the court pro se, meaning without an attorney. The last time that we were present, Mr. Smith had sought to relieve court-appointed counsel of her services and did not request new court-appointed counsel, thereby electing to proceed pro se. Mr. Smith, how would you like to proceed in your case?
I filed a motion just this morning. I'm not sure if
It hasn't been filed with the court yet, meaning they haven't uploaded it yet.
Yes, I hand delivered it just this morning.
All right, so we're looking to schedule a motions hearing.
Yes.
And what type of motion to put the people on notice?
Dismissal.
On what grounds?
Violation of constitutional rights.
All right, so a constitutional based motion. Are you alleging a violation of a particular section? Or are you alleging that the statute itself is unconstitutional?
It's predominantly the Fifth Amendment, 14th Amendment, in regards to legal counsel and due process.
In regards to legal counsel, you fired your attorney at your last appearance. You haven't sought appointment of a new attorney. In what way have your rights been violated there?
Well, on September 30th, when I was summoned to court on the court's docket to courtroom 103, I went over the building and was unable to find it until I finally intrigued with the guards who pointed me in the direction of the clerk's office. With that being on the docket as a courtroom, and the possible consequences of failure to appear that comes with more fees, fines, and possible jail time. I'm not sure why that's in the clerk's office where I was isolated behind closed doors without that legal counsel, which was before.
So in that instance, you're referring to a different case, not this case, 25R549. So nothing in relation to that case is going to be referenced in this case. To the extent that you're alleging other violations, though, we'll set your motion for a hearing. Keep in mind that motions deemed to be groundless, frivolous, vexatious, or otherwise contrary to law will not be heard. But I don't have a copy of the motion at this point, so I can't make that determination. We'll set it for a hearing on motions to the extent that any of it relates to this case, not some other case. And let's get a date.
Your Honor, I do have paperwork that does say that that is for the 2025R000549.
Right, that's a separate case. This is 25T435.
Okay.
Infraction cases operate under a separate set of rules, and those do get heard for first appearance at the court clerk's office. The case that you're before the court on in this courtroom right now is that 25T435. So the charges that you have in this particular case are higher level allegations than what you would have been initially for a first appearance authorized to appear in room 103 for the basis of, not the number 4. So again, we won't be hearing any contentions in relation to anything about the infraction case. I'll let you know as well that people are not entitled to have court-appointed counsel in infraction cases. But again, that's separate and apart from you're entitled to have hired attorneys, but the legislature does not authorize public defender or court-appointed counsel or similar to appear on those. And in addition, the district attorney's office doesn't appear on those cases either. All right, for a hearing on motions in this case, I can set a motions hearing on April 1st at 1:30. Can the parties accept that?
That was April 1st.
April 1st,
Yes, ma'am.
1:30.
Yes, ma'am. That is fine. At 1:30.
Correct. As it relates to this case, Mr. Smith, again, 25T435, we had some of this conversation last week. I just want to make sure to clarify on the record when the people are present that you are electing to proceed to a motions hearing and moving forward in this case by representing yourself. Is that correct?
I'm still in the midst of studying and trying to understand my own rights. So it's a challenge. It definitely is. I'm not going to lie about that. So the representing myself is still, I'm pending it in my stance of everything. Just because I'm in a financial hardship, so finding a free attorney to take the place of a public defender it's almost impossible.
Mr. Smith, I want to reiterate that the last time that we were here, you elected to essentially fire court-appointed counsel and proceed by representing yourself. Is that correct?
That was because I was under the impression that she was unable to defend me.
Unable to ethically file the motion that you sought her to file. Is that correct? According to her.
According to her, yeah, I'm sure.
And you did not seek an alternative defense counsel to be appointed to you. You elected to proceed without the benefit of an attorney at that time. That doesn't mean that you waive your right forever if you can find an attorney, but you were not requesting alternative defense counsel to be appointed to represent you, correct?
No, Your Honor, not from the courts.
And is anybody forcing you to decide to, at this point, represent yourself?
I feel more pressured into it, yes, Your Honor,
In what way?
because I don't have the defense of a public defender.
You had one, you fired her. So in what way are you being forced to do this?
I didn't necessarily fire her, Your Honor. When she refused to even hear me out when I mentioned a few words, that's not, in my understanding, it's not firing her.
We
I
had
was
a
pretty
pretty
shut down.
lengthy hearing on the last court appearance, Mr. Smith. Do you recall that hearing on the 9th of January?
Yes, Your Honor.
At that time, you no longer wish to have the services of the public defender, is that correct?
Yes, Your Honor.
And you did not seek appointment of alternative defense counsel, is that correct?
Not from the courts, Your Honor.
So that's correct, yes?
Yes, Your Honor.
And did anybody force you to do that?
No, Your Honor, I still feel pressured into it, though.
In what way do you feel pressured?
Your Honor, I was under the understanding that I have the right to an attorney, and if I cannot afford one, then one will be provided for me.
One was provided for you, correct?
Provided for me in the stance that she would not defend me.
And you did not request alternative defense counsel to be appointed to represent you, correct?
Not from the courts, no.
So nobody forced you to make that decision, is that correct?
Yes, Your Honor.
Was that your own choice?
Under coercion, yes, Your Honor.
Who coerced you?
The pressure from representing myself in this. I was under the impression that's what you guys were telling me, was since the public defender would not defend me, my only option was to seek my attorney on my own cost and time and effort, or represent myself.
Did you ask for court-appointed counsel, alternative defense counsel?
No, Your Honor.
Are you asking for that now?
No, Your Honor.
Is anybody forcing you to make that decision?
No, Your Honor.
Is it your own voluntary choice?
Yes, Your Honor.
Are you under the influence of any drugs, alcohol, intoxicants, or prescriptions that affect that decision?
No, Your Honor.
Do you understand that you're going to be held to the same legal standard as a licensed attorney?
I'm still under study and research and education of myself.
Do you understand that you're going to be held to the same standard as a licensed attorney?
To an extent, yes.
I'm telling you, you're going to be held to the same standard as a licensed attorney. Do you understand that?
Yes, Your Honor. Do I need to?
I'm not asking if you understand all of the things that licensed attorneys have had to go through in order to be licensed. I'm asking you whether or not you understand that the standard that you will be held to is that of an attorney.
I understand that part, Your Honor. I just don't understand the standards that they are functioning and operating by.
And nonetheless, you're not asking for alternative defense counsel to represent you. Is that correct?
Not from the courts, Your Honor. I have trust issues now.
All right. So you are not seeking to have an attorney represent you, someone who has been trained in this field and is licensed to practice law in the state of Colorado. Correct?
On my own accord and effort and time, I am seeking, so.
And you retain that right always, but you're not asking the court to appoint someone else
No, Your Honor.
for you. Is that correct?
Yes, Your Honor.
And do you understand that the top charge against you is failure to display proof of insurance, which is a class 1 traffic offense? You could be sentenced to up to 1 year in the county jail if convicted, or you could receive a fine of up to $1,000 or both. And that one is a 4-point offense. Do you understand that?
Yes, Your Honor.
And nonetheless, you're seeking to move forward, at least at this point, without an attorney to represent you.
At this point, yes, Your Honor. I'm still seeking on my own accord.
But you have filed a motion and you're asking the court to set a motions hearing and you don't have an attorney. So I want to make sure that you are validly waiving your right to counsel before I set this hearing.
I'm under the impression that you're telling me that I still have the right to seek an attorney on my own.
You do, but by filing this motion and asking for the hearing to be set when you don't have an attorney, then we need to talk about the waiver. It's not binding. You can change your mind. You can hire an attorney. However, at this point, asking to move forward without the benefit of an attorney and asking to set court time aside for a motions hearing does require a waiver of counsel if that is how you want to proceed.
I was not under that understanding at all. No one's here to advocate me as far as legal representation to.
So what would you like to do, Mr. Smith?
I'd like to move forward with the motion.
You want to move forward with the motion?
Yes, Your Honor.
Despite not having counsel?
Yes, Your Honor.
And again, just to confirm, is anybody forcing you to do that?
No, Your Honor.
And you understand the rights that you have. You were appointed an attorney, you relieved that attorney of her services, and you did not request new court-appointed counsel, correct?
To an extent, yes.
To what extent? It's a yes. Or no.
To my understanding that the public defender denied me, I didn't deny her.
She is no longer representing you, and you have not requested new
I do
counsel
understand
from
that,
the
Your Honor.
court, correct?
I do understand that, but I was not the one to initiate the denial.
And you did not request new counsel, which you
Correct.
could have, correct?
I'm seeking on my own accord, Your Honor.
All right. I do find a knowing, voluntary, and intelligent waiver of counsel. Certainly, Mr. Smith understands the rights that he has to be represented by an attorney. He was appointed an attorney. He did not ask for a new attorney when the services of the public defender were terminated. You retain the right to hire an attorney at your own expense and on your own behalf if you wish, or seek alternative defense counsel. You are not doing so. So at this point, I do find that knowing, voluntary, and intelligent waiver of counsel. We'll schedule a motions hearing on your motion on April 1st at 1:30. Keep in mind that the court cannot accept a letter from someone who is not here to testify or something similar. So if you're seeking to utilize the subpoena power of the state to obtain the appearance at trial of a witness who you may wish to have testify on your behalf, then you can go down to the court clerk's office and have subpoenas issued. And I believe that we already discussed how to get discovery. Is that correct?
Yes, Your Honor. I was provided that.
All right. So I'll note Mr. Smith believes that he has been provided discovery. I would encourage you, you're not required to speak with the district attorney about the facts of the case, but if you periodically want to inquire of their office whether or not any additional discovery has been provided in your case to make sure that there's that free flow of information, I would encourage you to do so. Anything further for Mr. Smith at this time?
Not from the people, Judge.
And Mr. Smith, is there anything further at this time?
No, Your Honor.
All right, so we're going to set that motions hearing as I've stated, and I'll encourage you to be prepared to proceed to the motions hearing. Anything further?
No, Your Honor.
Anything further, Mr.
No,
Smith?
Your Honor.
All right, and I just want to remind you that any allegations brought up in the motion that you filed in 25T435 that relate to the infraction case, which was that 25R 549, any of those issues will not be heard. Any rights that you may have from that case are separate and apart from anything in relation to this case. All right.